Good afternoon, everyone. Happy May. I can't believe it's May already. Welcome to our May 7th webinar, Common Mistakes When Drafting Rules. My name is Elena Gilbert. I will be presenting this one today. But before we get started, as you know, we do have to run through a few housekeeping items, but you can enjoy this really cute meme in the meantime. So on the screen, you should be seeing primarily the PowerPoint with this adorable German Shepherd puppy. And off on the left is your presenter. That's me. Hi, Alina Gilbert. On the right side, up on top, there's a little chat icon. Use that with questions. So you can type them in anytime. I will wait until the end of the presentation to answer questions. We usually have some time left, so hopefully we can get to your questions. Plus, a lot of times they get answered as we go through the presentation, so it doesn't make sense to stop in the middle and answer them. You will receive 1 CMCA credit for listening and watching this webinar. You will get an email with the credit certificate in about probably today or tomorrow. Now, keep in mind, and I always have to tell people this, it's really weird, but that certificate, the picture disappears after 30 days. So what you need to do is make sure you save the email and the picture somewhere in your computer so you don't pull it up later and it's gone. So just make sure you actually save the certificate, the picture of it, so you can have it forever and ever and ever. As a reminder, we are recording the presentation today. It will be up on our YouTube channel by tomorrow. So if you just love the presentation, you want to tell everyone you know to watch it, you can. And they can just go to our YouTube link on our website under education, and they can watch this and many, many other webinars that we've recorded over the years. Now, if you're having any issues with sound, with the computer, with connectivity, there's a little icon on the bottom that says video or audio problems. Click on that. It will take you through a few steps and hopefully resolve the issue for you. And finally, last but not least, there will be a little pop-up survey at the very end of the presentation once I'm gone. If you have time and the inclination, I really, really would appreciate any feedback you have. I don't care if it's Alina sucks. I don't care what it is, as long as we get some feedback, because we do read it. It does help us improve our presentations in the future. And so we really do care about your thoughts and what you like, what you don't like. And we appreciate the time you take to get that done for us. Okay, so now that we're done reading about Maisie, let's go ahead and get started. What are rules? We use that term interchangeably with policies, guidelines, resolutions. All those terms are mishmashed together, but technically they all have different purposes, even though we don't technically use them that way. But if you look in the definition of a rule, both in just like a regular Webster's dictionary and a legal dictionary, you are going to see something like these 3 bullet points. As you can see, they're all related to conduct. So prescribed guide for conduct, authoritative guide for conduct, specific enforceable standard that defines limits or controls behavior, right? So again, that's all conduct. And so ideally, when we draft rules, they really should be targeting conduct of your owners, of your association membership, as well as anyone else who may be on the property. So if it's something else, it might be better suited to fall under a different category, although legally speaking, you can call it whatever you want, and it'll still be just as enforceable. So where do we get authority for adopting rules? Community associations in Colorado, Kiowa has the Colorado Common Interest Ownership Act has a specific provision that says unless your governing documents expressly prohibit it, you as an association through the board can adopt rules and regulations. That's what it says, which means even if your documents are completely silent on the issue, you as a board may adopt rules and regulations governing the community. So that is a really good thing. So if you see something in your documents that says, rules may only be adopted with approval of the homeowners or something along those lines, you obviously have to follow that. But it's extremely rare to see something like that in a set of covenants. The other place we get authority to adopt rules, of course, is in the governing documents. Typically, we see it in the declaration, we see it in the articles, and we usually see it in the bylaws. Usually all three documents really reference that right. Primarily, though, the declaration should be the document that talks about that. But again, even if your declaration is silent, you do have that right under Kiowa. This right exists for all communities, regardless of when they were created. Okay, so it doesn't matter how old or new you are, you have the right to adopt rules, absent anything in your documents. So let's get into some of the common mistakes that we see when we review rules. And the first one, which I think we see a lot of, is conflict with governing documents. And I group these into two separate categories. One is a direct conflict, and the other one I made up, the stealthy conflict. And we'll talk about that in a minute. So a direct conflict is a set of rules that just on its face conflicts with what you have in your declaration. So for example, some things I've seen. No, your declaration says no commercial vehicles in the community. And then we have a rule that says commercial vehicles may be kept in the community with approval from the board. So it's carving out an exception. That's what a lot of these rules do, is they try to carve out exceptions to something that the declaration prescribes. But that's completely contrary to what the declaration says. If the declaration says no commercial vehicles, it doesn't say no commercial vehicles except, right? So you can't change the declaration through a rule and add exceptions. And really that is, I think, the basis for most conflicts that I've seen when reviewing rules, is boards that try to say, yeah, the declaration says this, but, here's some exceptions. Can't do that. Another one is maintenance. For example, the declaration requires the association to maintain windows, and then we'll see a rule that says any cracks in the glass must be repaired by the homeowners. So again, it's the board trying to carve out some sort of an exception to what the declaration provides. Can't do that. That is a direct conflict with what the declaration provides. So be careful with that when you are drafting rules. Make sure there's not any exceptions being carved out to what your declaration requires. The next one is the stealthy conflict. Ooh, stealthy. So what do I mean by that? I mean, it's not as completely clear and obvious that it conflicts with the declaration, but it does. So one example I always use, and you may have heard me use this before, is the reasonable number of pets one. I have seen lots of covenants that will say an owner may have a reasonable number of pets in the unit. Now, of course, as we know, the board can define what that reasonable number is. It's an ambiguous term, so we can have something that says a reasonable number of pets is 2 pets per unit. That's fine. But have you ever seen a board try to write a reasonable number of pets as 0? So it kind of looks like we're defining a term, which we're entitled to do, but we're really writing a rule that conflicts with a declaration, because by saying that you can have a reasonable number of pets, it is absolutely reasonable to conclude you can have at least 1 pet. So then to say a reasonable number equals 0 is a way to essentially prohibit pets. but you can't prohibit pets based on this provision in the declaration. So that's a stealthy conflict where you kind of have to think about it a little bit and go, is this really a conflict? Another one, leasing. A lot of times what I see associations do is you may have something in the declaration that says, all leases must be in writing. And then the board will adopt a rule that says copies of leases must be provided to the management company once they're signed or something along those lines. But the declaration doesn't require you to provide copies of the leases to the manager. So one thing to really understand and accept is that anything to do with leasing is something that has to be contained in the declaration and not in any rules. The reason is that leasing is a what's called a use restriction. When somebody purchases a property, you own property, there is this bundle of rights. It's a legal term. They give you this, you are automatically get this bundle of rights. And those rights cannot be curtailed except for in an agreement that's signed. Now, the declaration actually fits that definition. It is an agreement. Even though the homeowner doesn't sign it, it's still an agreement. It's recorded against the property, so the owner has legal notice of it. And any restrictions that are considered use restrictions have to be in the declaration. And that is specifically also what Kiowa says. And associations cannot change their use restrictions without at least approval from 67% of all the homeowners. So even if your documents say they can be amended by a majority of all owners, if you're going to change something like lease restrictions, you're still going to have to get 67% of the membership. So this is a really big deal. And leasing is a use restriction. We don't always agree on what a use restriction is, but leasing is definitely one of them. Another one would be something like if you're going to prohibit smoking inside units, that would be considered a use restriction. So those are the types of things that have to be contained in the declaration. You cannot do it through a rule. And a lot of times I see associations trying to adopt rules where they are trying to regulate leasing in some shape or form, and you just can't do that. Then there's we're creating these brand new restrictions that don't have any basis in the declaration. So what does that mean? I mean, if you've got some broad authority, for example, that says association can adopt rules and regulations, which is what Kiowa says, but then it goes on to say governing the lots, as opposed to just common areas, governing the lots, then we can make an argument that, yes, we can adopt a rule that says, you can't park an oversized vehicle on your driveway. We can make an argument for that. However, at the same time, if you have provisions in your declaration that talk about parking but never mention oversized vehicle, now it becomes a little bit contentious in that, do we really have the right to prohibit oversized vehicles if the declaration doesn't even speak to oversized vehicles? So sometimes it's a little bit of a touch and go, and we can try to argue it both ways, but in most cases, if your governing documents don't even mention it, I think the best practice would be don't make a rule about it, or at least ask legal counsel whether you can make a rule about it, because we got to have at least some general broad authority to be able to do this. All right, let's move on. All right, so the next one is associations that have rules that conflict with Kiowa. If you've been doing this for a while, you know that it seems like almost on an annual basis, we get new legislation that creates more roadblocks for associations to be able to enforce certain provisions, to do certain things, to prohibit certain things. We'll keep getting these additional limitations imposed by the government. So it is very difficult, I think, for both board members and community managers to keep track of what you can and can't do anymore. There's just so much out there, right? So these are some of the most common ones, but believe me, there's a lot more than this. I just Didn't want to spend an hour talking about all the possible, conflicts with Kiowa. Signs and flags. I have associations that still try to prohibit signs or flags from being displayed on a unit. But as you know, you got to allow at least one sign and one flag. It's not or, it's and on the property. If it's a condominium, you have to allow signs in the windows. If it's for a flag, you also have to allow a flag on the balcony if they have a limited common element balcony. You don't have to allow signs on the balcony. I don't know what the legislators were thinking in making that distinction. I can't logically figure it out, but whatever, it is what it is. I see a lot of associations still going back to the whole, hey, political signs, you can only have them during this time in the season, in the election season. Well, that used to be a thing, but that's all gone now, because now our sign and flag provisions in Kiowa say you cannot regulate based on content. Oh, yeah, and that's content. So you can't have specific rules governing political signs. You can't have special rules governing the United States flag anymore. You cannot have anything that references the content except commercial signage. You can prohibit commercial signage, but that's about it. Xeriscape. Can't prohibit xeriscape, right? If you've got a single family home, people have their lots, or even, you have to allow the artificial turf in the backyard. You can't prohibit that. You have to allow xeriscape plans. You have to have your 3 pre-approved garden design, plans on the websites. So be careful when you're drafting rules to make sure that they're not in a way that conflicts with the current xeriscape requirements. You cannot require more than 80% of the lawn to be green. You cannot require certain things. You can't prohibit people's plans to put up their gardens if it's not one of the pre-approved plans. They still have to submit it, and you have to review it. And unless there's something in there that conflicts with our guidelines, we have to allow it. So be careful when drafting any kind of rules or even guidelines that specifically talk about the xeriscape, and make sure that those do not conflict with any of the laws, as we keep getting updates to the xeriscape provisions. Fire hardened building material. What is that? That's a recent one, right? And nobody really knows what fire hardened materials is. It's not clearly defined, but we know it's not wood. It's not something that can easily catch on fire. So if you've got rules that say all fences have to be wood, or all outbuildings have to be wood, that's not going to fly, because wood is not a fire hardened building material. So those need to get updated to make sure that they allow for other types of materials. And you don't have to spell out the fire hardened materials, but you can say, all plans to add improvements to the property, regardless of what it is, must be submitted. So something even like that, but we don't want to have anything that says it has to be wood. We cannot do that. EV charging stations. So, that's our electrical vehicle charging stations. Have to allow those in limited common elements. So a rule that says no EV charging stations in any common area is likely a conflict with Kiowa, because if they have limited common elements, we have to allow it there. So again, if you've got rules governing the charging stations, you also want to make sure that those do not conflict with anything in the statute. Energy efficiency measures. So that would include a lot of different things, but primarily we look at solar panels. You can't prohibit solar panels on property owned by the homeowner. So what does that mean? What do they own? Well, if it's a condominium community, they obviously don't own the building. That's a common element. But right now there is a bill waiting for the governor to sign it, which would also protect portable solar panels. So they're literally portable solar panels that you can put on your limited common element balcony. And assuming the governor signs it, that is going to be now allowed, and we're not going to be able to prohibit that either. So, kind of keep an eye out for our blogs as far as that particular bill. But again, can't prohibit your solar panels, can't have rules that increase the cost by more than 10% or decrease the efficiency of it by more than 10%. So a lot of times I see associations adopting rules for solar panels that say, no more than 20% of the roof may be covered by solar panels. That's not going to fly because that's going to be a reduction in their electricity savings by a lot more than 10%, and we're not going to be able to do that. So that's a thing too. ADUs are now protected. Again, single family detached homes where you have lots. So it's not going to apply to your condominiums. It's not even going to apply to your townhomes, but it will apply to your single family communities. We have to allow the ADUs, right? Obviously we can regulate them to some extent, but we can't prohibit them. So a lot of times I will see rules that say no alternative, living spaces outside, the residence. Well, I can't do that because that's an ADU, and we have to allow them now. Home-based businesses, that's another one we can't prohibit anymore. Oh my God, we can't prohibit anything, right? Home-based businesses. So rules that say no businesses out of the home, you got to take that out because now that's a violation of Kiowa. Even if your declaration says no businesses out of the home, guess what? Doesn't matter because the law is going to overrule that. You can't enforce that kind of a covenant anymore. And then public right-of-way regulation. This one, I actually like this one because I think this is nothing new. It's just been codified. But that basically says, hey, if you've got public streets running, through your community, public right-of-ways. Now, keep in mind, public right-of-ways isn't necessarily just the streets. A lot of times, if you've got the little green belt between the street and the sidewalk, that's part of the public right-of-way. The sidewalk can be part of the public right-of-way. But what this says is associations cannot regulate in any way, shape, or form what happens on public right-of-ways. So let's think about this. You sit on the board or manage a community that has sidewalks and public streets. And we have a rule that says you cannot leave garbage cans overnight on the street. Can't do anything about it. Let's say you have a rule that says you can't leave garbage cans outside for more than 24 hours, but the garbage can is out on the public street. You can't enforce that because you are not allowed to, specifically not allowed to do anything governing what happens on that public right-of-way. And the municipalities still haven't figured it out because a lot of times, I've had managers or board members call the municipality saying, hey, can you do something about this car parked on the street or about this trash can? And they say, oh, well, you should be able to do that through your association rules. And the answer is no, we can't. The law prohibits us from doing that. But for some reason, the municipalities have a really hard time kind of figuring that out. So if you have had that experience where you call or you email and they say, oh no, this is for the association to handle, just know they're wrong. They are wrong, and maybe reach out to the association's, legal counsel to discuss it. Because you can't do anything about it. All right, let us move on. Conflicts with federal law. All right, that's a kind of a big one too. So there's a lot of federal laws really that impact associations, but the one I want to talk about today is the Telecommunications Act, FCC. It's the FCC over-the-air reception device rule, which if you kind of look at the acronym, it's OTARD, OTARD. It's an unfortunate acronym, but that's what it is. But we have a lot of associations that have rules governing satellite dishes. For example, you need to get prior approval before putting up your dish. The dishes must be installed by a licensed contractor. Well, here's what the FCC says about satellite dishes. It's actually about any antenna that's protected by the Telecommunications Act. So that does not include ham antennas, before you ask me, or the shortwave ones. But satellite dishes that are intended to receive, communication signals for your television or whatever else, those are protected. And anything that's 1 meter in diameter or less is protected. So you can have a provision prohibiting satellite dishes that are greater or larger than 1 meter in diameter. That's fine. But anything that's less than 1 meter, you can't prohibit. You cannot have any rules or covenants. It doesn't matter if it's in your declaration or not. You cannot have any kind of restrictions on your satellite dishes that in any way, shape, or form increase the cost of it, or in any way, shape, or form decrease the signal that you can get, like the channels. Like if I'm telling you have to install your satellite dish on the west side of your roof, and you can't get all the same channels on the west side as you can on the east side, then I can't tell you, I can't enforce that rule. Now, before we get to kind of the rest of this stuff and its implications, I do want to distinguish between planned communities and condominium communities, because those are treated very differently. The protected satellite dishes are only protected on property that is actually owned by the association, or property where the homeowner has the exclusive right to use. So a limited common element, which is only used by the one owner. That's where they are protected. So when we talk about a condominium community, for example, we have a condominium building. Keep in mind the roof of the building, the siding of the building, those are all general common elements, and there is no protection there for satellite dishes because those portions are not owned by individual homeowners. They are common elements. However, a satellite dish within the limited common element balcony would have to be allowed because that's an exclusive use area, and that's also a protected location. When we are talking about townhomes and single family homes, doesn't matter, the homeowners in those cases own the actual structure. The association may maintain it, especially with townhomes, but the homeowners own it. And that's really the only thing that the FCC is concerned with. If you own it, you can put your satellite dish on it. So you can't prohibit homeowners in a townhome community from putting up their dishes on the roof or on the siding or wherever they want to put it up, or in the window. You don't get to prohibit that, and you don't get to tell them where they have to put it up, because if they can't get the same kind of signal where you're telling them, then they don't have to follow that. What else can you not do in your rules with these types of communities? Well, you cannot require prior approval, because what does that do? That delays the installation. If a homeowner has to submit and wait for you to approve it, that's a delay. That's not allowed under the FCC rules. So what can you do? You can require notification that someone has put up an antenna within a certain amount of time afterwards. That you can do. What's the point of doing that? Is you will then have a formal record of which homeowner put up a satellite dish and where. So if there's any damage as a result of the satellite dish being put up, that you could still charge that back to the homeowner. That you can do, right? They don't get to ruin property that we have to fix without having to pay for the fix. So satellite dish rules are inherently problematic, especially in townhome communities and single family communities, just because there are so many restrictions under the federal laws as to what we can and cannot do with the satellite dishes. So I would recommend, I always recommend that you make sure everything gets reviewed when you are trying to adopt the various rules with respect to your satellite dishes. So the rule of thumb is, especially with townhome, single family, there's really very little you can do. You can require notification after the fact. You can give a pecking order to the homeowners of like, we prefer, if at all possible, you install it here. However, if you cannot get a good quality signal here, then our next preference is here. Our third preference is there. Our fourth preference is over here. So you can give them that, but really short of that, there's not a whole lot you can really do when it comes to homeowners installing their satellite dishes. All right, I'll move on. Let's talk about discrimination. And that is another one that is, well, this is both a federal and a state thing. There are fair housing laws, both at the state level and the federal level. The FHAA is the Fair Housing Amendments Act. It's the federal it's the federal law that talks about discrimination. The Colorado Fair Housing Act is similar. We actually have even more protections in our act, more protected classes than they do in the federal one. So it's pretty harsh here. And I always like to tell people, is discrimination unlawful? Well, it's really not. It's not at all unlawful. We discriminate all the time, but the issue is you cannot discriminate based on a protected class. That's when it becomes unlawful. So I can decide I want to hire someone at the firm who's got 5 years of experience. Well, that's a form of discrimination because I am carving out some people, a lot of people, from being able to have this job. It's still a form of discriminating, but that's not illegal. Now, if I want to hire someone and I say no disabled people are allowed to apply, that is huge. That's a big discrimination, right? Because disabilities are protected under all fair housing laws. So I'm going to talk about three kinds of discrimination, even though the third one isn't on here. But the first one is going to be familial discrimination, which is anytime, I see rules that talk about children, restrict ages, no one, you must be accompanied by an adult at the pool if you're, less than 14 years old. Well, that is a huge form of discrimination. Is it discrimination against children? No, children are not a protected class, but it is a discrimination based on family status, which means families with children are treated differently than families without children. And that is a form of discrimination. Now, what do most associations do with the swimming pool is kind of one where we can sort of carve out an exception for safety concerns. But what you would have to do if you were going to have an age restriction for the pool is basically say that for safety purposes, and you really don't want to go higher than 12. Anyone under 12 must be accompanied by an adult, but then you got to add, unless that person can provide proof of swimming proficiency or swimming ability by providing us with something like a Red Cross certification or some other kind of certification that shows they can swim. So what we're trying to get at is if I'm a 10-year-old kid and I'm on the swim team and I'm training for the Olympics in 5 years, I can probably swim better than most adults. So for an association to say you can't swim unaccompanied if you're under 12 for safety reasons, well, that doesn't really apply to me because I'm a really, really good swimmer. So we have to provide the ability for these younger persons to show to us that they are proficient swimmers. Now, I'm not saying you have to give them swimming tests and then you judge whether or not they can swim. That's not what I'm talking about. But what I'm talking about is, like I said, a Red Cross certification, or they get a letter, a certified letter from the swim coach at their school that says this person's on the swim team. They are competent swimmers. They, can hold their own. Something like that. Something where we're not making a judgment call. If we get that, then we can't say no anymore. Communities that have adult swim can't do that. What you can do is lane swimming, like 7 a.m. to 9 a.m. You can only do lap swimming. That's fine. But if a kid wants to lap swim, you can't say no. So those types of restrictions are not going to fly. I see a lot of restrictions that say toys must be picked up from the common elements by 9 p.m. Well, why toys? Why not other things? Why is it just specific to children? Why isn't it all recreational equipment or all personal property? Right? I mean, there's no reason to not make it all encompassing and only target those things that are specific to children. So you kind of have to be careful with the rules when you're drafting those, that you're not either specifically targeting children or you're not adopting rules that have the impact of only applying to children. Either way, it's considered discrimination. Then we have religious discrimination. So this I see in rules where, for example, we have rules that govern holiday lights. And it says, I've seen rules that say, lights may be put up 5 days before the holidays and must be taken down 10 days after the holiday. However, for December holidays, they can be put up on November 15th and must be removed by January 15th. So you see the problem there, right? Not all religions fall within the December holiday season. And to have different rules for different types of holidays, religious holidays, that is you treating different religions differently, which is exactly what is defined as religious discrimination. So you want to be super careful with those types of things. The last one I do want to touch on that isn't in here because it doesn't come up in rules that often, but it still comes up, and that is the disability part. Associations have to provide reasonable accommodations and modifications to folks in the community, and if they're disabled. And, like I said, normally this only comes up when you get a request that says, hey, I'm disabled, I want a parking spot. Or, hey, I need to bring my assistance animal to the pool because I can't be there without it. Things like that. But a lot of times what I've seen, well, maybe not a lot of times, that's an overstatement. Sometimes what I've seen is rules that say no pets are allowed, no animals allowed in the clubhouse except seeing eye dogs. I've seen that. But guess what? There are a lot more assistance animals out there than just seeing eye dogs. First of all, we've got emotional support animals, and that could be anything. They don't need to be certified. You can also have an assistance animal that is a miniature horse. That and dogs are allowed to be true assistance animals that go through the training. So to say the only assistance animals that are allowed are the seeing eye dogs, you're essentially discriminating against other forms of disabilities that use other types of assistance animals. So be careful with that. Don't even mention any kind of assistance animals in your rules because the law already addresses it. You would already have to allow them via reasonable accommodation. So you don't need to put anything extra about that in your rules. Be careful with that. All right, enforcement. So you all know that Kiowa requires every association to adopt its 9 good governance policies, right? One of those policies is the enforcement policy, and it should be extremely specific given all the requirements of the law of all the things you have to put in there. And that should be the only place where we talk about enforcement. However, There are many sets of rules that I have reviewed personally where the board tries to put the enforcement process in the rules, excuse me, as well as they have a separate enforcement policy. Well, first of all, why? Why would you not say violation of these rules would be enforced in accordance with the association's enforcement policy? Two, a lot of times I see different things in the rules as far as enforcement than what's in their enforcement policy, which was specifically drafted, if it was drafted by legal counsel, to comply with all the current requirements. And so chances are, if you're putting any kind of enforcement language into your rules, chances are they're not complying with the law. And they're also probably contrary to what your policy says, which does nothing more than create confusion for your homeowners and an ability to challenge what you're doing. So don't do it. If you're going to mention any kind of enforcement, just say it's going to be in accordance with the enforcement policy. Also, don't put the fines in your rules. Fines should only be in your enforcement policy. Don't also threaten immediate fines. If you violate this rule, and an immediate fine may be imposed against you. No, because Kiowa doesn't allow for immediate fines. You're never going to be able to do an immediate fine. You always have to go through the process set forth in the enforcement policy. So if you have that kind of language, take it out. Just refer to the collection policy and kind of go from there. Towing. Towing is also become it's always been regulated for the towing companies, but in recent years, there's been more and more updates to towing laws to also address requirements of towing from private property and specifically HOAs. So before an association can tow, it really has to comply with all these specific provisions. You have to have specific signage. It has to be of a specific height and specific font, a specific size. It has to be in English and in Spanish. There's all sorts of really minutia type details that are required to be followed. Now, if they're not followed and you call a tow company and say, hey, tow this vehicle, if it's a legitimate tow company, they're going to say no, because we're going to get in trouble for towing when all these things are not yet done that have to be done per statute. You have to have the signage. You need to have 24-hour notice. You need to have this. You need to have that. There's a lot of stuff that goes into that. If you tow from your community, hopefully your towing companies are providing you with appropriate signage and also with the appropriate stickers to put on the windshields. However, my recommendation is to have a towing policy as well. That will help you, the manager, you, the board, make sure you follow the correct process every single time you are towing, because the last thing you want is an improper tow. And then you got a very upset homeowner, and now they're demanding you pay for not only their towing fees, but now they're going to tell you the car was damaged and you need to pay for that, and all sorts of stuff. So be careful when you're putting any kind of rules in that deal with towing. You don't want to threaten immediate towing. Immediate towing is only allowed under certain very specific circumstances. You don't want to threaten towing for expired license plate tags, because that's not even allowed. You can't tow for that reason alone anymore. So be careful if you're talking about towing, and think about having also a separate policy for that process to make sure you are following what the law requires. So that is kind of my condensed version of common mistakes. So the next logical discussion topic is, how do we protect the association? How do we protect the board from having rules that can get them in trouble? And the first step is please make sure whoever your attorney is for your community, that they review your rules. I'm not saying this because I want to make an extra buck, because I assure you're going to spend a lot more money on legal fees if you have rules that you're trying to enforce that are discriminatory or unenforceable, and then you have a homeowner going after you, you're going to incur a lot more legal fees. So I'm not trying to have you spend a lot of money on attorneys for the sake of spending money on attorneys. I'm trying to convince you that this is a preventative thing. All the things we just talked about, hopefully demonstrated kind of all the stuff that's out there that could possibly go wrong. It's not even all the stuff. It's maybe 50% of the stuff, if that. There's a lot more laws. There's a lot more document provisions that may be getting violated. So please, if you take nothing from this presentation, just take this. Have your attorneys review any rules that are drafted by the board. Have them review any modifications to the rules, because that is really the only way you're going to catch those issues. And I'll be honest with you, I've been doing this over 25 years. That's all I'm going to say. And I have reviewed many, many, many sets of rules. And I have never, ever, though, reviewed a set of rules where I said, yeah, I got no changes to this. Everything's perfect. Everything's in compliance with the documents, with the laws. Never has that ever happened. So you do the math. Please have your attorneys review. Now, the second part of that is, please follow what your attorneys are recommending you do with the rules, because they're not just telling you to change this or delete that because they want to be difficult. They're telling you this because they know what the law is. They know, they read through your governing documents. They know what they say. And they also know what has caused problems for other communities in the past, even if it's not specifically a conflict of the law or a conflict with your documents. There's just simply a lot of problematic types of rules that are adopted that in a practical sense are nearly impossible to enforce and really get associations in trouble or can expose them to liability. So follow the advice of your legal counsel. They're not trying to make your life difficult. They're trying to keep you protected from liability. Okay. And then finally, and some people think I joke when I say make sure you have appropriate liability insurance. I'm not. I'm completely serious, because that is your last line of defense, because we can't control who's going to sue us or when, whether or not it's a legitimate reason or not. Regardless, if you get sued, guess what? You're going to have to pay an attorney to defend you. So let's make sure your insurance covers that. Excuse me, sorry. I almost just jinxed my sneeze. So make sure that you've got a policy that's going to pay for your legal fees, minus the deductible, if you do get sued. Even if you didn't do anything wrong, you still have to spend legal fees to defend yourself, to prove to the court you didn't do anything wrong. So there's really no way around that. Make sure, when I say appropriate liability insurance, I mean your commercial general liability policy, your CGL, as well as your directors and officers, your D&O policy. Make sure you have those. Make sure the coverage is adequate. Make sure you know what your deductibles are, if any, for the liability, and submit the claims if you're getting sued, because if you don't submit it within a certain amount of time, a lot of times you lose your right to submit, and then you can't submit it later. Meanwhile, the attorney fees start to rack up, and now the association's wondering how it got to $50,000 of legal fees without any insurance coverage. So those are the best ways to protect both the association and the board. And honestly, it also protects management, right? So follow these steps. Please do them. Now, we are ready for questions. So we got a good 11 minutes here. And I will look through them here real quick while you all read these funny little things. All right. I will move us on. Okay. I will let you watch the pig and chicken while I read questions. Owners in a community repaired or replaced fences a few years ago. Many owners did not follow the guidelines when replacing them. How does the HOA handle this since it has been more than a year? I mean, that's really more of an enforcement question. If it's been more than a year, it depends. If they replace them and it's been more than a year, you're really not going to be able to do much of anything. at that point, other than send them letters. Let's see. I'm going through them pretty quick. I'll make sure we go through all of them. I have short-term rentals. The declaration says no pets for short-term rentals. Can they say that in the rules? No. If you're going to govern specific like leasing issues, again, you want to make sure those are in your declaration. Also, for various reasons, I don't recommend treating your renters differently than your owners. There have been some cases, not in Colorado, but nationally, where a renter sued based on discrimination because the association had different rules for renters. And when you looked at the demographics, we found that the renters fit into a certain protected class of people based on their race. And so the court said, hey, you know what? This is, discriminatory. So don't do it. I would not treat renters differently. All right. Can you prohibit flags depicting explicit language? Nope, that's content. You can't govern content. Conflicts with Kiowa only applies to post-Kiowa communities. Yes? No. The things that we talked about here today apply to all communities regardless of when they were created. If we undertake a total update to our declaration, would we still be considered pre-Kiowa? Yes, you would. But again, all these restrictions that we talked about today would still apply to you because they apply to all communities. If a homeowner submits a plan that for xeriscape and later sells the home and the new homeowner requests the HOA to put it back to its original shape, does the HOA have to comply? Does the HOA need documents attached to the ownership documents advising that HOA is not responsible for putting the lawn back to its original condition? So if if the association maintains the lawn and we let an owner make modifications and the condition is you're maintaining all your modifications, yeah, you better have an agreement with that owner and it better be recorded in the county so that there is legal notice to future owners that this is their responsibility to maintain. Otherwise, they have a pretty good argument that it's your responsibility to maintain. They may not be able to make you put it back the way it was, but they may still have an argument that you have to maintain it the way it is. If the declaration specify that there is no street parking, is that in violation of the public right-of-way? If the streets are public, then that covenant cannot be enforced because it's not part of the HOA. It's a public street and it's a public right-of-way. Does the rule regarding public right-of-way allow commercial signage, etc., on those green belts? If the green belt is part of the public right-of-way, homeowners can do whatever they want with them without the association having any say. And it would really be, if they're violating local code, someone could try to report them to code enforcement and try and have the municipality enforce its code. But that's about the only thing you could do. The association can't do anything. Let's see, sorry. You mentioned public streets cannot have restrictions. What about private streets within the community? Sure, private streets are common elements for the most, usually, and they are property that's either owned by the association or maintained by the association, and the association does have authority to adopt whatever rules, on common area and govern the common area. So yes, you can do that. What about limiting the age of use of a sauna that could be dangerous for younger children? You can't really do it. I would just say put a sign up that says use at your own risk, because that's really the safest way to keep, that's how you keep the association safe. Look, you're using it at your own risk. Parents, you got to keep an eye on your children. Association is not a parent. We are not responsible for keeping children safe. It's the parent's job. Let's see. let's see, I consider rules and regulations part of the governing documents. Am I wrong in thinking this? Well, technically, we do consider them part of the governing documents, but when we talk about the hierarchy of the governing documents, they're on the bottom, which means if they conflict with your bylaws, your articles, your declaration, your plat map, guess what? They're not, you can't enforce it. So they are kind of part of that group of governing documents, but they're at the very, very bottom. I've been seeing the 9 good governance policies in properties in the rules and regs. This does not seem to be a good idea in practice. Thoughts? So I'll tell you, under Kiowa, at least your enforcement policy and your collection policies have to be separate, standalone policies. They cannot be part of your rules. That conflicts with the requirements. The other 7 policies, technically, I guess, could be part of the rules. I do not recommend that. I think then it all gets convoluted because they're not rules. They're policies that talk about procedures. That's what policies are. They're the processes. And so that's what makes them policies versus rules. They don't really govern behavior. My recommendation is to keep them all separate and apart so you don't have to revise your entire packet of rules when you need to change one policy. Would it be recommended for the HOA's legal counsel to draft the rules and regulations directly, or would it be better for the HOA board and management team to prepare the initial draft rules and then have the attorneys review? That's a great question. And my recommendation would be to have the board with management draft the rules. The reason is that we attorneys, we don't live in your community. We don't really know what the issues are that you deal with day to day. So if we drafted rules, they would be extremely broad. They may not even apply to things in your community, and it would be a waste of your money to pay an attorney to draft rules. It's much better for the association to do it and then have the attorney review it, because otherwise you're just going to be paying us to draft generic language that we have no idea whether or not it applies to you or not. Let's see. I have an HOA that restricts unreasonable levels of light pollution unless it's reasonably necessary for security and safety. There are some homes that have house lights that don't have ARC requests, but may have been up for several years, and now homeowners are complaining. Can permanent house lights be considered use for security and safety? And can the board add rules that say these permanent house lights must be turned off by 11 p.m.? What I find to be more effective is requiring lights that are motion activated, because then they'll turn on if anyone approaches the house. So it still provides the security, but it's not like they're always shining. Be careful about requiring homeowners to turn off lights. If they have a break-in because they had their lights turned off, guess who's going to be responsible and have a liability exposure? The association is. So be reasonable with your rules. Talk with legal counsel with respect to options when it comes to people complaining about lights. Okay, we got 2 minutes left. We are getting ready to do some asphalt work. We have been told the residents that they need, we have told the residents they need to move their vehicles by 7 a.m. the week of the work. Can we bring a tow truck on site to immediately tow those vehicles? No, you cannot. You cannot immediately tow for that. You have to put the 24-hour notice. You still have to have all the signage. So you're not going to be able to immediately tow. And if you incur additional costs because of it, because they can't do all the work and then they have to come back and do more, then arguably, assuming your declaration has language, you might be able to charge those costs back to the owners who didn't move their cars, but you can't immediately tow in that situation. Let's see. I think this is the last question. Our board was advised that in order to tow a vehicle of a non-resident, a contract and signage by towing company. Yeah, we talked about this is required. Yes. Do towing restrictions apply to non-residents occupying exclusive use space for a resident in a condominium building. It applies to everyone, whether it's a guest or a resident or whoever. The towing laws apply to, they're really targeting the community itself, not individuals. So you have to comply with all the requirements before you can tow anybody. All right, I know there's more questions and I am not going to get to them because it's 1 o'clock. Feel free to email me. You have my email. Just as an FYI, I am heading to the Bahamas tomorrow. So if you're emailing me, don't expect a response back for at least a week because I will be on the beach drinking pina coladas. But feel free to email me and I'll get back to you after I get back from vacation. Thank you for joining me. Please, if you have time, please do the survey and have a wonderful day. And we'll see you all later.